President Muhammadu Buhari signed 8 bills into law at the National Assembly, passed the National Assembly into law. That's one of the bills is the Legislative House's Power and Privileges Act 2018. Now the law grants members of the legislative houses in the National Assembly and state houses of assembly immunity from litigation for actions taken in plenary or committee proceedings. Well, I have joining me in the studio a lawyer, Inibehe Effiong, to bring his perspective on this very issue. Good to have you here.
Thank you for having me.
On the News Hour. So now, by virtue of this law, which grants the lawmakers immunity, what do you perceive will be the likely implications?
The starting point is to correct the impression that has been created in the media that this is a new law.
Okay.
On the contrary, this is a law that is over 60 years. It actually came into force on the 30th of April, 1953. It is as old as that. During when the then House of Representatives, under the during the British rule, introduced this law into the then Parliament. So this law has been in existence. What the National Assembly has done by amending the law, which is the Legislative Houses Powers and Privileges Act, Cap L12, Laws of the Federation of Nigeria 2004, as amended in 2018, is basically to further expand the scope of certain matters under that act, specifically relating to powers, for example, powers to summon persons to appear before committees, and also giving them what you could consider privileges or immunities, basically from proceedings for actions taken during committee hearings or at plenary. This is not a new law. This law has been in existence. And we also need to say that it is not peculiar to Nigeria. You also have a similar provision or a similar enactment under the American Constitution, specifically under Article 1, Section 6 of the American Constitution. You also have it under Section 26 of the Constitution of France, which basically guarantees legislative or parliamentary immunity. Why that of Nigeria is generating controversy per se, I think it's because of the culture we have had. There has been a tendency in Nigeria for things to be used in the negative. So Nigerians are alarmed that what does this really mean? We need to say that this act cannot give immunity for offenses that has nothing to do with the performance of legislative function, because that would be a violation of Section 308 of the Constitution, which clearly articulates constitutional immunity and limits it to the president, vice president, governors, and deputy governors. However, we have to say that until we have seen a copy of this act, it will be difficult to give a conclusive meaning on what this new law means. But we must note that this is not peculiar to Nigeria. This law is necessary to the extent that members of parliament, both at the federal and the states, should be protected for exercising their legislative power within the ambits of the law. Because you can imagine a situation where a member of the National Assembly is making contributions on the floor of the House and is afraid that he may be arrested for comments he makes. So it is important for them to be protected. It is the extent of protection that is an issue. So I am effectively saying that provided this law does not go beyond what is envisaged by the Constitution, there is nothing wrong in it.
So if it goes beyond it, what do you think would like to happen?
No, it can't go beyond, because that would be a violation of the Constitution. As I have said, the Constitution is specific on persons who enjoy constitutional immunity. What the National Assembly has done is now to bring actions within the contemplation of the Act. Because under the Cap L12 of Laws of Federation 2004, specifically Section 3, you only have protected comment, speech made during course of functions in the House. It did not include actions. So I think that is where they are extending the application of that act. But I must also say that those actions must be specifically within their legislative functions. However, it is important to note that criminal actions, criminal infractions can be committed while performing legislative function. For example, budget padding, which has generated controversy. And you must also know that this could be a reaction to the trial of the Senate President for allegedly forging the Senate standing orders of 2015. I believe this is a reaction to the case filed by the federal government against Senator Saraki. But whatever it is, by the time this law comes out and we see it, if it goes beyond what I have said, it will be clearly unconstitutional. But as long as what is sought to be protected is exercise of legislative function, I don't see anything wrong in it. Furthermore, we must note that even under the Constitution, specifically Section 88 and Section 89, as it pertains to the National Assembly, you also have protected the power of the National Assembly to summon any persons and even issue warrant of arrest where that summons is violated. Even the Houses of Assembly enjoy similar power under Section 128 and 129 of the Constitution. So I don't think there is any cause for alarm. I don't think there is any need for controversy. This is not strange. This is not new. This is important for democracy. Parliament must have the ability to exercise their powers without fear of actions being taken against them.
All right, another positive note. I'd like to thank you very much, Inibehe Effiong, for analyzing this issue for us and making us understand the pluses on this law passed by the president. Thank you very much indeed.